2. Judicial decisions support a broad reading of Section 1512C2. Courts have not limited Section 1512C2 to conduct that impairs evidence, but instead have read it to cover obstructive acts in any form. As the court explained, this expansive subsection operates as a catch-all to cover otherwise obstructive behavior that may not constitute a more specific offense like document destruction, which is listed in C1. United States versus Volunpezdo 746F 3D 273 286 of the 7th District, 2014, some quotation marks omitted. For example, the United States versus Ring 628F Supplement 2D 195 DDC 2009. The court rejected the argument that 1512C2's reference to conduct that otherwise obstructs, influence, or impedes any official proceeding is limited to conduct that is similar to the type of conduct prescribed by subsection C1, namely conduct that impairs integrity or availability of records, documents, or other objects for use in an official proceedings. ID at 224. The court explained that the meaning of C12 1512C2 is plain on its face, i.e. alterations in the original, and courts have upheld convictions under Section 1512C2 that did not involve evidence impairment but instead resulted from conflict that more broadly thwarted arrests or investigations. See e.g. United States versus Martinez 862F 3D 223 238 2nd Circuit 2017. Police officer tipped off suspects about issuance of arrest warrants before outstanding warrants could be executed, thereby potentially interfering with an ongoing grand jury proceeding. United States versus Arnzenfeld 698 F 3D 1310 1324-1326 10th Circuit 2012. Officer disclosed existence of undercover investigation to its target. United States versus Phillips 583 F 3D 1261 1265 10th Circuit 2009. Defendant disclosed identity of another undercover officer, thus preventing him from making controlled purchases from a methamphetamine dealer, whose cases illustrate that Section 1512C2 applies to corrupt acts, including by public official, that frustrated the commencement or conduct of a proceeding, and not just to acts that made evidence unavailable or impair integrity. Section 1512C2's breadth is reinforced by the similarity of its language to the Ombudsman Clause of 18 U.S.C. 1503, which covers anyone who corruptly obstructs or impedes or endeavors to influence, obstruct, or impede the due administration of justice. That clause of Section 1503 follows two more specific clauses that protect jurors, judges, and court officials. The Ombudsman Clause has never been construed to be far more general in scope than earlier clauses of the statute. United States versus Aguilar, 515 U.S. 593, 599, 1995. The Ombudsman Clause is essentially a catch-all provision which generally prohibits conduct that interferes with due administration of justice. United States versus Benson, 104 F3D, 1267, 1275, the 11th Circuit, 1997. Courts have accordingly given it a non-restrictive reading. United States versus Kumar, 617 F 3D 612 620, Second Circuit Court, 2010, ID at 620 and 7. Collecting cases from the 3rd, 4th, 5th, 6th, 7th, and 11th Circuits. As one court has explained, the Ombudsman Clause prohibits acts that are similar in result rather than the manner to which the conduct described in the first place of the statute. United States versus Howard, 569 F 2D, 1331, 1333, 5th Circuit, 1978. While the specific clause forbid certain means of obstructing justice, the Ombudsman Clause aims at obstruction of justice itself, regardless of the means used to reach the result, i.e., collecting cases. Given the similarity of Section 1512C2 to Section 1503, Ombudsman's Clause, Congress would have expected Section 1512C2 to cover acts that produce a similar result to the evidence impairment provision, i.e., the result of obstructing justice, rather than covering only acts that were similar in manner. Read this way, Section 1512C2 serves as a distinct function in the federal obstruction of justice statute. It captures corrupt conduct other than document destruction that has the natural tendency to obstruct contemplated as well as pending proceedings. Section 1512C2 overlaps with other obstruction statutes, but does not render them superfluous. Section 1503, for example, which covers pending grand jury and judicial proceedings, and Section 1505, which covers pending administrative and congressional proceedings, reach endeavors to influence, obstruct, or impede the proceedings, a broader test for inchoate violations that Section 1512C2 attempt standard, which requires substantial steps towards completed offense. See United States versus Sampson, 898 F 3D 287 302, Second Circuit, 2018.